In the litigation against Illinois' gun and magazine ban, there were, of course, thousands of temporary restraining orders issued, keeping individuals and gun stores that signed on as litigants against Illinois' gun and magazine ban safe from having the law enforced against them. Attorney Thomas DeVore brought one suit that had hundreds on it, secured a temporary restraining order out of Effingham County, challenging Illinois' gun ban, and then he filed several other lawsuits with thousands more individuals and gun stores as part of that in different counties, White County, and then also again in Effingham County. Then you had the Macon County case. That went all the way to the Illinois Supreme Court, and they heard that last week. Well, that was in Macon County where the case originated in state courts. So there's an effort at the State House that would essentially prohibit somebody from filing an action in state court against state actors like the legislature or constitutional officers like the governor or the attorney general, and only it limits those lawsuit filings not anywhere across any county courts, but only in Sangamon County, the seat of state government here in Springfield, but also Cook County. Not down in, Macon County or Effingham County or White County, only Sangamon County or Cook County. And this is a measure that was amended to a House bill. It passed the Senate. It's got to go back to the House for concurrence. But Senate President Don Harmon on Friday laid out his bill and what exactly he's looking to accomplish with this measure. Here's Senate President Don Harmon.
Thank you, Mr. President. Ladies and gentlemen of the Senate, House Bill 3062 is a very simple amendment to the Code of Civil Procedure. It directs that any action brought against the state or its officers seeking declaratory or injunctive relief against any state statute, rule, or executive order based on an alleged violation of the Constitution of the state or the Constitution of the United States shall be brought either in Sangamon County or in Cook County. I'm happy to answer any questions.
All right, tons of questions.
Is there any discussion? Senator Tracy.
Thank you, Mr. President. I'd like to speak to the bill, please.
To the bill.
Jill Tracy.
Actually, I would like to ask.
Indicates he will yield.
Mr. President, I'm just wondering why you chose two counties. I get why you choose Sangamon County, but I'm wondering why you think Cook is more important than all the other 100 other counties besides Sangamon County.
President Harmon.
Thank you, Mr. President. Thank you for the question. It's one I asked as well. The statutes are actually replete with jurisdictional references to Cook and Sangamon as the two primary jurisdictions. I think it's the same reason that I have an office in Springfield and an office in Chicago. Leader Curran has an office in Springfield and an office in Chicago. The governor, the attorney general, all the constitutional officers have an office in Springfield and an office in Chicago. It is essentially an alternative place of government.
So there's Senate President Don Harmon laying out his rationale for limiting lawsuits against the state and state court to just Sangamon County and to Cook County. Now, this would not impact federal courts, from my understanding. This would just impact state litigation. And we've gotten a lot of lessons in litigation against the state's laws, not just during, the mandates of COVID-19 with the mask mandates and the school mandates that there were that Attorney DeVore really spearheaded. But now we're looking at, of course, the gun ban and all the litigation there's been in state courts, not just federal court. Again, the federal court's totally separate. But in state court, you had the Effingham County case that led to the Fifth Circuit Court of Appeals siding with the plaintiffs there, essentially saying that their case could advance on the merits, and that's ruling laying over other counties in that challenge, including Macon County and White County. So those are not Sangamon and Cook counties. So this measure from Senate President Don Harmon would require that only Sangamon and Cook County can have these lawsuits filed from individuals. So say somebody from Cairo wants to file a lawsuit against the state, they would have to travel all the way to Springfield to file in state court, or fly up to Chicago to file in state court. That is not something that is feasible in a lot of people's minds, including some state lawmakers that continue to raise questions about all of this.
Why aren't every county in this state is important to every citizen in Illinois. They are part of the Illinois Constitution, and why would they not be able to bring a cause of action under the Constitution of Illinois in any county in this state?
President Harmon.
Thank you, Mr. President. They can bring a great variety of causes of action, including those relating to the Constitution in any county. This is a very limited case. It's where the cause of action is against the state itself or one of our officers seeking declaratory or injunctive relief against a state statute on the basis that it's in violation of the Constitution. These cases are almost inevitably on their way to the Supreme Court. They are typically consolidated, and what we have seen recently is similar cases being filed in scores of counties, causing the Attorney General to have to defend the same action in multiple counties with forum shopping. This is a simple effort to make sure that all important critical constitutional questions end up in the right venue.
So, Senate President Don Harmon essentially saying that people are forum shopping whenever they file outside of Sangamon or Cook, and this is an effort to try to cut down on that. I do want to read the First Amendment, though. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Is this considered an abridgment of that right to petition the government for redress of grievances? We'll see if this ultimately stands and if it passes the Illinois House, but here is more in that debate going back and forth about this bill to limit individuals to only file lawsuits against the state. It doesn't matter if you live in East St. Louis. It doesn't matter if you live in Cairo. It doesn't matter if you live in Effingham. It doesn't matter if you live in Des Plaines or Quincy or wherever else throughout the state. If you have a complaint you want to lodge, if you have a grievance that you want to have the government address, this bill says that you would have to do it in Sangamon County or Cook County, not in your home county. Again, more of the debate from Friday night on the Senate floor about this measure from Senate President Don Harmon.
The constituents that I represent have a right to have access to me and have a right to have access to bring their grievances before this state. What's happening with this bill is anyone who brings a suit against a constitutional officer has to come to Springfield or go to Chicago. That is absolutely absurd for citizens who live in Cairo, in Alexander County, for people who live in Carbondale, who live in Jackson County, for people who live in East St. Louis, who are in St. Clair County. Every freaking time that I have to go to Chicago for a hearing, simply because it's inconvenient for someone to come from Chicago to Springfield, gripes me. Imagine what is going to happen, or how the feeling of the citizens of this state are going to be whenever they have circuit courts that they can go to so that their cases can be heard, only to be told that we don't want constitutional officers or officers who right now are actually being sued to have to be inconvenienced, so they're able to go to Springfield and Chicago, but the citizens of this state have to be inconvenienced to go wherever they want that to go. This is a terrible bill. We have circuit courts in this state for a specific reason, and that is so that people are able to go to their courts and have their grievances heard, not so that we can make it more convenient for the person that was mentioned previously, which is the Attorney General. This is a very bad bill, and every single one of you should be paying attention to this, because you have a responsibility, I have a responsibility, the sponsor has a responsibility, even the Attorney General has an office in Carbondale. Why? Because he wants to be close to the people that he's serving. This is a terrible bill. Vote no.
So that's State Senator Terry Bryant from Murfreesboro, who is very adamant that this is, as you heard, a terrible bill, she says. You also had State Senator Jason Plummer, who laid out his concerns about this piece of legislation and how it's going to impact his constituents in Southern Illinois, and how Southern Illinoisans are going to be able to petition their government for redress of grievances.
The legislature does not work for the constitutional officers. And the judiciary and the legislature and the constitutional officers work for the people of Illinois. And it's time that you start showing some respect to the people of Illinois, quit limiting their rights, quit taking their rights away, and frankly, when we take their rights away, at least give them the decency and the respect to allow their concerns about their rights being taken away be heard in a local courthouse. This is an affront to democracy. I urge a no vote.
So Plummer calling it an affront to democracy. And then to close, Senate President Don Harmon laying out why he thinks this bill is necessary.
Again, if you're trying to solve a local dispute, you can go to your local courthouse and file a claim and have your case addressed by a local judge. We're not proposing to take that away. If you're raising a question of the fundamental constitutional rights, you are inevitably heading to the Supreme Court. You are inevitably heading to Springfield or to Chicago. And if you were to prevail in your local courthouse and it was appealed up through the appellate court, if you don't come to Springfield to argue your case before the Supreme Court, you will lose. These cases are all going to end up in Springfield or Chicago. It's our judgment that it is best to simply streamline that process and make sure these cases are all heard in an organized fashion.
But obviously, when you've got a challenge to, say, a measure that was passed by the legislature and enacted by the governor that people say is unconstitutional, they'll get a ruling out of the circuit court in Effingham that'll be different than if they were to go to Cook County to get a ruling out of that circuit court. And that ruling could be a temporary restraining order, blocking the law from being enacted, as we saw in Effingham County for named plaintiffs, as we saw out of Macon County, which there was dispute as to whether or not that judge there blocked the law statewide. Now, state police and the governor, they all say, no, it didn't block it statewide, it only impacts the plaintiffs. But it was deemed unconstitutional by the Macon County judge, and if it's deemed unconstitutional in Macon County, then it's deemed unconstitutional everywhere. That was the argument. But if you limit where people are able to file their actions against the state, then that circuit court action, you're essentially taking away the option of them getting a favorable ruling for the plaintiffs while the case continues to go through the appellate process and then gets to the Illinois Supreme Court. Again, this is a measure that passed the Senate. It's a House bill that was amended. The Senate amended it. Now it goes back to the House. We'll see if they pick that up and obviously bring you the latest debate here on that measure and